The Federal High Court and the Kano State High Court have issued conflicting interim injunctions on the Kano Emirate, escalating tensions and uncertainty in the state. The Federal High Court in Kano, presided over by Justice S.A. Amobeda, issued an order for the eviction of Emir Muhammadu Sanusi II from the Kofar Kudu Palace, reinforcing the authority of the 15th Emir of Kano, Aminu Ado Bayero. On the other hand, the Kano State High Court, under the jurisdiction of Justice Amina Adamu Aliyu, issued an injunction to protect Muhammadu Sanusi and other key figures from potential harassment by state authorities. These conflicting orders have led to significant confusion regarding the rightful authority and protection of the emirs in Kano State. The State High Court's case is set for further hearing on June 13, while the Federal High Court has adjourned its case to June 4. As both courts prepare for their respective hearings, the people of Kano State await clarity on the matter. And now joining us virtually is Sunday Wogira, a legal practitioner, to give us further perspectives on the saga in Kano State. Thank you so much for joining us on the News Hour.
Thank you very much. Good evening.
Good evening. Now, we're dealing with an already complicated situation becoming more complex, especially looking at the conflicting and irregular dispensation of looking at the conflicting and confusing court orders. What is your reaction to the battle of the courts in Kano?
Well, they said, as it is said, rather, the judiciary is the last hope of the common. Not just the common, but even the mighty of the mightiest. And you have seen how everyone comes to the court to seek for cover and protection. The grouse is that at the center of all this was the court, but the lawyers involved. Lawyers are going to court, they are misleading, and at the same time going to court to mislead the court. And they ended up making a caricature of the whole judiciary, which is most unfortunate and reprehensible. That is exactly the situation we have found ourselves today as a people and as a nation. If you look at the first injunction issued by the Federal Court, you will clearly get to understand that the judge was misled into giving that issue, because lawyers in their own treachery and in order to fulfill the wishes of their clients went to court before the Federal High Court, not on any chieftaincy matter, but under the guise of enforcement of fundamental human rights and the protection of same by the fundamental human right of the applicant before the Federal High Court, the Agundi. And that was mischief of the highest order by the lawyers in the matter. I blame entirely the lawyers in that matter for that mischief. Whatever bashing the judiciary is receiving today is as a result of the treachery of the lawyers in that matter. That matter has nothing to do with the enforcement of fundamental human rights. But knowing that they could not get that order within that time, they had to resort to misleading the court under the guise of protection of the applicant's fundamental human rights. I am of the firm conviction that in the long run, when the whole the judge is abreast of the whole matter from the respondents and the applicants, that matter will be dismissed.
Okay.
Because, sorry, the Federal High Court does not have the jurisdiction to entertain chieftaincy matters.
Okay,
so
you have stated
now,
that we're technically making caricature of the judiciary at the moment in the country, but I'd like to hear from you. At what point do we expect a body like the NJC to step in and mitigate the unusual and irregular dispensation of justice?
Well, the NJC should not be left alone in this crusade. The NBA as a body must also step in. Lawyers who would go and mislead the court, obtain theoric orders that will end up making a caricature of the court, must face disciplinary actions.
Okay.
And I think undertakings like in political cases must be extracted from lawyers at the same time when filing this matter, that this is strictly an enforcement of fundamental human rights issues and has nothing to do with any other triviality.
Thank you so much for insight. Just before I let you go, just before I let you go, I have one final question for you. Legally speaking, I mean, how can the web of court orders be untangled?
Well, sometimes judges must also be circumspect in issuing orders of this nature, taking into cognizance the timing and whatever. There is nothing wrong in the court, instead of giving this injunctive relief ex parte, to order that the respondents or all parties be put on notice, and they should come and give reasons as to why injunctive reliefs should not be issued or ordered.
Okay.
And when they come to before the court, I think it must not be 7 days. These days can be abridged, and the court will save itself the embarrassment we are seeing now.
All right, thank you so much for your thoughts on the Kano Emirate saga. There we had a legal practitioner from Yola, Sunday Ugira. Thank you so much for your thoughts on the News Hour.